over to you. Do you want to introduce ourselves to everyone on the webinar today?
Yeah, thank you very much, Darren. Well, good afternoon, everyone, and thank you very much for joining today's session on global data protection legislation. I've invited Fifth Step to run this presentation today. In fact, Fifth Step are going to look at our own GDPR compliance to make sure that we put in our processes and procedures. But also what they're going to do is they're going to help us to put in a GDPR audit model for our clients should they wish to go down that route. The reason why I've selected Fifth Step is that they are specialists in compliance primarily across the financial services and insurance sector, and they have got a number of experienced data protection officers globally that support clients with GDPR. Darren himself has been working with the Data Protection Act throughout his career, and he's actually speaking at the IOD on the 17th of October, specifically on GDPR at the IOD Digital Security Strategy event. So thank you very much, Darren, for running today's webinar, and I'd like to hand over to you, Darren. Thank you.
Great, thank you very much, Chris. Well, we've got a quite good presentation here for you today. I'm going to start moving this through. Now, I hope everyone can see this. This all seems to be working from our end. So if there are any glitches or anyone not able to see the presentation as we go through, please do put that into the chat window so that we can see and be aware of that, just because sometimes we can be completely oblivious to the fact that things have perhaps stopped moving along from your side. We are also
I can't see your screen. Apologies for that.
Oh, well, that's the good start there. So, okay, I've just started resharing that again. I hope that that's going to start working. Let me just make sure that that's all in there. Okay, is that any better, Chris? Can you see that?
Perfect, spot on.
Marvelous. Okay, well, that's good. Right. Okay. We are also recording this this event, so we will make this available as a podcast as part of the Fifth Step on the Fifth Step podcast channel. I'll give you details of how to find that later on, and you should get an email after the event as well, allowing you to subscribe to that and listen to it again. So, cracking on, the learning objectives. This is just a high level what we want to achieve from today. It's very much about increasing your understanding, but also giving you some actionable steps and some things that you can start to look at for your organisation, and giving you some some timely advice around GDPR. GDPR is one of those topics and one of those subjects that there is a lot of fear and misunderstanding about, in my opinion. So today we won't be dealing with the fear factor, because actually GDPR is just one of those things that businesses have to deal with. It's a risk like any other business risk. So we'll be dealing with that and treating it in that way. Now, it wouldn't be appropriate for me to start a GDPR presentation without mentioning the fines that can be induced. This is usually the point where people start drumming up the fear. Okay, the numbers are big. Okay, the fines can be as great as 20 million euros or 4% of your global annual revenue, whichever's the greater. Okay, so it isn't just 20 million euros if you are a Google or someone like that who have a turnover of billions of dollars globally. It would increase. It would be the 4% of the global annual revenue, which would be used. Okay, so those are the scary bits, and that's why people get upset about it or get nervous about it, and that's where people who play on the fear aspect really drum that piece home. I'm not going to do that today. I'm just, as I said, I'm going to walk you through it and hopefully make everyone feel quite comfortable about it. Okay, so here's some of the brief headlines. GDPR applies to companies irrespective of their location who are collecting, storing, or processing personal or sensitive information about EU residents. Actually, I've made one of my cardinal mistakes there. It's actually not Yes, sorry, it is EU residents. Many people will be saying EU citizens, and it actually doesn't have anything to do with citizenship. It's actually to do with about residency, where you're actually based. Okay, so the key aspect there is that if you are processing, and that means collecting, storing, transforming, viewing, any of those things, any data that is considered to be personal data or sensitive personal data that relates to EU residents, okay, you have to be following the GDPR. And that goes for whether you are based in the United States or in Australia or in France or in the UK, okay? The fines I've already mentioned, I'm not going to revisit those. And importantly, GDPR applies to UK-based companies irrespective of Brexit. This is another big question and misunderstanding. The UK government has already said that they will be maintaining compliance and equivalency with GDPR. It's absolutely vital that they do that. And the last one, GDPR will be enforced from May 2018. It's actually May 25th, 2018 that you have to be compliant, that it will be enforced from. Okay, some of the key terms. I'll run through some of these. These are all really the important ones. I'll run through some of these, and some of them we'll sort of pick up as we go along. But some of these are the key ones, and these slides will be available after the webinar as well. Okay, so the data controller. The data controller is the person, the company or organisation who determines the purpose and the manner of processing of the personal data. Okay, so it's very much the organisation. Acme Widgets Limited has an HR department. They are collecting their data for the purpose of employing staff. That organisation, Acme Widgets, is the data controller in that respect. Okay. Below that, in the green box, we define the purpose. So this is under the Data Protection Act and under GDPR. You are only allowed to collect data for a specific purpose or purposes, and you have to define those, and you can't change those after you've collected the data without revalidating with the data subject, the person who the data belongs to. You can't change that, okay, after the event without the data subject's consent. So it can be multiple purposes, doesn't just have to be one. But those have to be clearly laid out and clearly defined so that the data subject is well informed and knows exactly what it is they're signing up for. Consent is a big part of that, and personal data, absolutely key definition as to what personal data is. We're going to pick that up in more detail as we go through this webinar and make it clear what personal data is in respect to HR data, which is an absolutely, HR departments are a really rich vein of personal and personal sensitive data. A data processor is anybody outside of the data controller who processes the data on behalf of the data controller. Okay, so that can be a third party. So if you outsource your payroll processing, for example, the likelihood is that organisation is going to become or will be a data processor in the eyes of the GDPR. And sensitive data there, just to touch on that one, sensitive data is a special type of personal sensitive data, and there's some specific categories, and we'll talk about those ones as we go through too. Okay, the rights of the data subject. Now, these are the core rights. So this is really the fundamentals of the data subject's rights under the GDPR. What we're showing here is the right to be informed. Why don't I run through them quickly? Okay, the right to be informed. This is the right to be informed about what the data is going to be used for. And that has to be, unless unavoidable, has to be before the personal data is provided. Okay, so that may offer some challenges in an HR setting, and we'll talk about some of those. The right of access. Any data subject, so the person who's provided the data, has the right to ask for access to the personal data that the organisation, that the data controller holds on them. Okay, under the under the GDPR, that request has to be fulfilled within 1 month of the request. Now, it can be extended by up to 2 months further in particularly complex cases, but it has to be explainable that it is actually a complex case. It can't just be extended for no good reason, just because you don't have enough staff to fulfill the request, for example. So you have to be able to fulfill that within 1 month. The right to rectification is having had access to the data. If a data subject recognises that some of the data you're holding on them is incorrect, you have to be able to correct that or offer the ability to correct it. So in an HR setting where you're actually holding details about staff, you may, for example, provide your staff access to your HR system so they can maintain their own records. That would definitely satisfy that requirement. But you also have to think about people who perhaps haven't joined the organisation, whose CVs you may be holding for a period of time, for example. If they were to request perform ask for their personal data and then notice that some of it is incorrect, you'd have to be able to correct that on their behalf for them. The right to erasure, this is often called the right to be forgotten, and this really relates to data subjects being able to request the deletion of their data. Now, in an HR setting, this is a curious one, and you can't really perform or fully perform that role in a normal setting, because you need the information in order for that person to be an employee. Now, once they've left the organisation, there is certain data you have to keep. In most jurisdictions, there's certain data you have to keep for taxation purposes, for example, in which case you can't fully comply with a complete erasure request or right to be forgotten request in that case either. So an organisation does have the right to refuse the right to be forgotten, but again, it has to be justifiable. It has to be for good reason, not just because it doesn't suit that organisation or because their systems don't support the erasure of, the deletion of certain data, for example. The right to restrict processing. This, again, really goes back to if the data is incorrect. Outside of the HR field, if you can imagine a situation where a bank perhaps has details about a data subject, they receive a request for the data. The data subject notices that there's perhaps 2 or 3 people living in an apartment block with the same or similar name, and that some of those details are being confused between those individuals. Well, in between the time of the data being rectified, being corrected, the data subject can ask for the right to restrict processing. So for that data not to be used during the course of or until it's been corrected. Okay. In an HR sense, again, that may you may be able to think of examples that I'm missing there, but in an HR sense, it's a little bit more. It's not going to be as common, shall we say? The right to data portability, again, this is going to be a very interesting one for some of the financial services, where particularly the comparison websites, the credit card comparison websites, the insurance comparison websites, for example, where data subjects have the right to be able to request their personal data in a common format, an industry accepted format. So the ability to take their data and to give it to another organisation who's going to provide a similar service. Now, in an HR sense, I can very much see this being something that's going to be requested as part of a leaver process. It may be that the data subject could ask for their information to be provided in that format, in a common format, so that they can take it to their next employer and have that information imported directly into their system with no possibility of the information being miskeyed. The right to object is very similar again to the right to rectification and the right to restrict processing. if the data subject feels that their data is either incorrect or is not being processed in a way that's consistent with the purpose that it was collected for, they have the right to object to that processing. And at that point, the processing would be restricted and would be stopped completely whilst that is investigated. The right to manual processing, again, in an HR sense, I'm struggling to think of a good example, but if I go back to the banking example again, you can imagine a situation where a bank has an automated system to approve or disapprove mortgage applications, for example. If that bank has an automated process and the bank says no, or the computer says no, then the data subject has the right to request manual processing. Now, what that actually means is that a person has to look at this information and has to be able to then make a judgment as to whether they agree with the computer's decision, or whether they actually think that the person should be allowed the mortgage and the computer should be overridden. So in an HR sense, I can't think of a particularly good analogy there that would work, or a particularly good situation, but it's something that you need to be able to consider, and that you need to that your systems need to be able to cater for. Our HR system department's different. I think HR systems and departments themselves are different because of the amount of personal data they actually collect. It's very difficult to think of another part of an organisation that collects so much personal data. If you were looking for a source of information that would allow you to clone identities of people, HR departments are the ideal location. You've got the person's name, address, their social security or tax numbers or national insurance numbers, for example. You've got passports or identity numbers, particularly for European citizens. You've got data that's often extracted, perhaps going to other systems such as Payroll system, for example. And it's often held in multiple systems, perhaps for jurisdictional requirements. Sometimes data is held in a European system, but has to be reconciled to a system in another part of the world, for example. And often the information is stored in document management systems for medical information might be maybe based in that way. And many organisations, I'm sure there's people on the webinar today, many systems still have a component of paper-based filing too. So that maintaining that filing cabinet in the corner of your office, or filing cabinets in the corner of your office, actually falls in the scope of the GDPR. So that's why I think that HR departments are special. And that also brings us to the need for an HR data controller. Now, this is something that Chris and I have talked about at some length, and the correct terminology for this. But we finally agreed on HR data controller. Now, you remember the term data controller is actually defined as an organisation or entity that determines the purpose and the nature of collection of the data for the entire organisation. Well, that HR data controller does that just for the HR data. So this might be the head of HR, someone like that, a very senior person within HR, and they would work with the data protection officer, so the top person, the person really responsible for data within an organisation. They would work with that person to ensure that they are remaining compliant with the GDPR. But with a particular focus on HR data and a particular understanding of HR data. So they would understand the HR data purpose and define the HR data purpose, understand and validate the data classification, and as I say there, work with the data protection officer to ensure the security and compliance with GDPR and other data protection requirements around the world. I know we have people on the line from Bermuda, for example, and other jurisdictions, but the EU isn't the only location where there are data protection requirements for individuals. Bermuda has its own requirement, for example, PIPA or PIPA, which will be coming into place in a similar time frame as the GDPR. So it's important that HR departments understand those. I said, promised earlier on that we'd talk more about personal data and how that's defined. There's the full definition there, and I'll leave you guys to read that rather than reading that all out to you. But that's the full definition of personal data as defined by the GDPR Article 4. And the GDPR, the text itself, is freely downloadable. If you just do a Google search, you'll find, well, you'll get lots of hits, but if you look for GDPR regulation or even search for GDPR Article 4, you'll probably get, you'll reduce the number of hits and be able to find the regulation to be able to download that and look at that if that's useful for you. So for HR departments, I think the key pieces of information that become personal data are things like names, passport ID or ID number, national insurance tax numbers, social security IDs, bank account details, any assessment information. So any judgment that you make on an individual is also covered by the GDPR and considered to be personal information. And employee ID. So the key aspect here is that in the middle or the second line of the definition there, it talks about the information can be used to identify a person either directly or indirectly. And that's why all these ID numbers are actually, they're indirect ways of identifying an individual. So combined with another data source, you could identify an individual purely from their passport or from their national insurance or social security number, or from their employee ID, for example. That's why all of those ID numbers are considered to be personal information. And as I said earlier on, physical copies of documentation are very much within the scope here. The first two words there of Article 4, any information. It's not any digital information or any paper-based information. It's any information, irrespective of the way it's stored or the medium it's stored on. Personal sensitive data. Now, as I explained earlier on, it's a different class of sensitive data, and it really goes to very personal aspects. Some of the information captured here is information that has been used to persecute people previously, whether it be ethnicity, trade union membership, sexual orientation, those kind of things. Health information is also covered at this point as well. And a new addition to the GDPR is biometrics and genetic information. That's also now considered to be personal sensitive information. Personal sensitive information has to be treated with additional care, and there has to be additional risk assessments around the information and the way that it's stored. Many organisations are encrypting everything to do with personal sensitive information to help reduce the risks. The GDPR itself does not mandate that. Early editions of the regulation did actually suggest that encryption was going to be enforced for personal sensitive data, but that's not actually enforced. For HR departments, I've said this a couple of times already on the webinar, it's a rich source of sensitive information, personal information as a whole. So do make sure and take special note of the different classifications of data that your HR department is holding. The first right within the GDPR is the right to be informed. So the data subject understands exactly why the data is being collected. You can't be informed without understanding why the data is being collected and how it's going to be used, and to some extent how long it's going to be kept for. So a data collection purpose very much defines that, and that's a key part of the Data Protection Act and the GDPR is presenting that information to the data subject, and in all but exceptional cases, you have to present that information before the personal information is gathered. Now, that's not always possible. For example, in an HR setting, someone may email their CV or their resume to you. They may do that, without any prior warning or request. In which case, that's perfectly acceptable that they haven't been given the collection. They've offered the information freely, understanding that they're providing that information to be used for the purposes of a job application, whether that be speculative or advertised. That's the case. Best practice would say that you would respond to any CVs that you're actually going to use and maintain, and with your data collection purpose in that case, and provide the data subject the reassurance that the data isn't then just going to be added to a marketing database or something like that, or sold on, which without their permission would be illegal. And you must also ensure that if the information, their personal data, is going to be accessed by third parties, that those third parties are clearly listed within the data policy and the notification of the data purpose. Combining HR and payroll systems is one of those areas I personally believe is going to become a real hot topic for HR departments over the next couple of years. Well, probably less than a couple of years, over the next year, as the full impact of the GDPR starts to sink in. My statement that I make there at the top: the more intersections and exports and interfaces that the system has, the greater the risks. Now, the reason for that is that as you export data, particularly if you're exporting it into a spreadsheet, for example, once you've exported it into a spreadsheet, even if that spreadsheet has a password applied to it and is encrypted, you do lose control of that data. It moves outside of the protective and controlled enclave of HR, and potentially enters the Wild West, because a spreadsheet can obviously be emailed around very easily. Our email systems are very efficient at spreading and distributing information like that. And if it's only protected by a password, well, passwords can be emailed around as well, particularly where it's a static password. So there are very good reasons for not emailing around personal information. I will actually just talk about one small anecdote. This one amused me greatly, and I'm trying to remember the country, but I think it was Sweden. It's one of the Nordic countries anyway. Relatively recently, a large IT company was doing a large project for, I'm going to carry on saying Sweden, but the Swedish Driver License Association. So these are the people who are processing all the driving licenses and things like that. And this particular IT company, they emailed in an unencrypted spreadsheet all of the personal information of all of the people that were currently being processed. When this was pointed out to them, they then replied to that email saying, "Oh, please delete all of this information as it's highly sensitive." So they then compounded the problem by pointing out how useful and sensitive this information was, and then just asked the third party to delete it. Those kind of things, whilst I really hope that those of you on the webinar today aren't doing those, aren't emailing spreadsheets with that kind of information in clear text. Those kind of mistakes do happen. Partly because staff don't always understand the sensitivity of the information they're dealing with, but partly because it's very easy to do. It's very easy to export information from systems. So look at the risk assessments or perform risk assessments based around how your systems are interfacing with other systems in your HR system estate. Minimize the exports. and extracts that that are performed. If you do have to extract data, to provide some interface or to do payroll or something like that, do the risk assessment around that. But at the very least, I would recommend that you start to increase the seniority of the people who have to do that, or who actually can do that, to try and minimise the risks associated. In putting together this this webinar, I was thinking very much and working with some of Chris's team. We spoke about the life cycle of an employee life cycle and their personal data life cycle, really, and try to put together some key points in an employee's stage, the stages that an employee goes through, and some of the data that might be collected at that point in time, and how it might be used, thinking about how it might be used. So this, I think, is it's hopefully for you guys a useful diagram as well. I'm sure that you've thought about this, perhaps thought about it in different ways, and I'm sure that you can add further examples, specific examples for your organisation when you look at it and you try to consider it in this way. But the key aspects here are that there are very different stages where you're going to be collecting data and processing data, potentially in different ways. The key aspect here is that you have controls, and that your systems support controls at all of these junctures, and that you can ensure the security and the privacy of the data, particularly the personal data and the personal sensitive data, but all of the data that you're collecting as part of an HR department. Data retention is a really hot topic. Whenever I speak to HR people about GDPR, there's always lots of questions about data retention. Now, what the GDPR says about data retention is that you can't keep a personal data or personal sensitive data beyond the time that is reasonable for the provision of the purpose. Okay, so if someone's providing their CV, as in this example, if they're providing their CV to you, they're not expecting you to maintain that data or keep that data for 20 years, for example. That's likely to be considered unreasonable. Now, if they're providing that information to you as a CV archivist, someone who keeps and collates CVs for some strange hobby, then obviously they're entering into that with a whole different agreement, and your purpose, your data collection purpose, would state why you're collecting the data, and that you're collecting it as an archivist, not offering them a job. So you have to consider what is reasonable for your organisation. What's a reasonable retention period? So what I've tried to define here and on the next slide is some reasonable retention periods. For your organisation, you may think, actually, we need to keep the data for longer, or actually, we wouldn't want to keep it for as long as that. And that's all fine. It has to be appropriate to your organisation. But here's some best practice guidelines that I put together for the purpose of this webinar. So you can see the couple of key stages here. The CV or resume is submitted right at the beginning here. That kicks off the process, and we've got the initial personal data is collected. It may be in an unstructured form, in the form of a resume. So the name and telephone number, email address may be at the top of the document, maybe at the bottom of the document. It's not going to be in a database or in a structured form. You may transcribe it into one, of course, but in the way that it's provided, it's not necessarily going to be structured. Okay. Ideally, at that point, you've made the candidate aware of the purpose and the data retention policy, so they know that you're going to keep the keep the CV on record for a period of time, and if they have any real concerns about that, they can obviously reject, or they can ask for the data to be deleted at some later time, if that's appropriate. Here we've used the role field date plus 2 years. Now, why 2 years? Well, 2 years seemed like the upper limit in my experience of where you'd actually want to go back and try and revisit or hire someone who you'd spoken to before. In some instances, you may want that to go longer if your organisation retains people for a particularly long time, and once you've found someone who's got a really good CV, you want to be able to go back to them, even after 4 or 5 years. That's absolutely fine as long as you can justify that to the Data Protection Authority, in your country or in the region that you'll be dealing with them. Should there be a data breach, then you need to be able to explain that. Now, during that post-hiring phase, the candidate could obviously come back at any point in that time and say, what data are you holding on me? What personal data do you hold? In which case, you have to be able to go back and say, well, we got on file your resume, we've got on file your telephone number, and some details about when we interviewed you. Now, at that point in time, if they feel that they would never want to work with your organisation, they could actually ask to be removed and invoke their right to be forgotten, their right to erasure. And at that point in time, you'd have to be able to honour that, unless it was a particularly complex situation, or the data was required for some secondary purpose which they'd already been made aware of. Okay, so as I said earlier on, you can deny some of those requests, but they have to be, again, it has to be defensible, not just on the grounds that actually we don't want to delete that information. It's more convenient for us if we keep it. Now, obviously, employment is a little bit more complicated. There's more touch points. It's a longer duration, and I've tried to detail out and capture some of that. Any diagram of this kind is always going to be a simplification. So, you guys looking at this, you might think, oh, well, we've got that situation or this scenario, and we need to be able to cater for this and that as well. So, build those thoughts into into what I'm presenting here as well. But I've broken this down into a number of areas here, really the 3 areas. And you could say that making someone a pensioner could also be another stage, but I've covered the 3 key areas here of employment. So when an employee first joins, they enter into a probationary period. You're going to do the majority of data collection at this point. The employees, the employee ID is going to be assigned, their name, their address, their next of kin details may well be collected at this point in time. If you're working within a jurisdiction that requires formal identification, validation of identity, such as passport or ID card, you're going to be capturing that information. Right up until the point when the probationary period is passed. Now, usually, most organisations, certainly at 5th step, when someone passes their probation, we have an interview and an assessment takes place there. We'll be capturing that assessment information. Obviously, as I mentioned earlier on, assessment information is considered to be personal information too. So we'll be capturing that information, and as their employment continues, we'll be collecting more assessment information, more personal information about them, more information about their next of kin, potentially. If their situation changes, if they get married or make a civil partnership or something like that during that period of time, their situation changes, perhaps they get divorced, you'll be collecting and updating, or having them ideally update their own information as they go through, right up until the point of the last day of their employment. Okay, at which point the clock starts to tick as to how long you can then actually retain their information and who should have access to that information from that point. Now, what I've done here is I've broken this down into a number of different groups, and you'll notice that right up until the last one, I'm saying that the information should be deleted or highly restricted. Now, highly restricting the data in some cases might be the most attractive thing to do, in order to that should that person rejoin the organisation, then you have all of the details and the information still on record, and you can re-enliven those, for example. But you have to consider, serious consideration as to whether it's reasonable to maintain that information and just restrict the processing. In most cases, restricting the processing will be perfectly fine, okay? But you need to make sure that that's reasonable at all points. So I've really laid out here that you've got the last day of employment plus 6 months and the last day of employment plus 1 year, and then we go on over onto the far right where we've put the last day of employment plus 7 years. So plus 6 months, we're restricting or deleting sensitive personal information. If the person hasn't rejoined within that 6 month period, then at that point we're taking the decision as to whether we want to keep their information, their sensitive personal information, any longer than we already have.
Can I ask you a question about this?
Yeah, please do, Chris.
So based on this model, if you then hold data in multiple sources, so that you've got both paper-based data, you've got an HR system, you've got a payroll system, you've got other systems. This is going to make it very complex then for being able to delete that data at that particular point, to be able to control that data. Do you want to comment on that, please?
Yeah, it does. You're right, Chris. There's one of the points I'll make a little bit later on is the greater that you can simplify your HR system environment, the less complexity, the less chance of error, the less retention mistakes you're going to make, should I say. So, if you're going to delete data and you've got a combination of a digital system and a paper-based storage system, for example, if you're going to retain that information in the paper-based information, if you want to retain that and restrict access, then obviously you're going to move it into a different filing cabinet that only the head of HR can access, for example. If you're going to delete it, then obviously you're going to need secure destruction capabilities. If it's a digital system, then deletion becomes that little bit, or potentially becomes that little bit easier. But you may actually decide that you want to delete all of the personal data in one go and retain and restrict access up until that deletion point. But very much, Chris, to re-answer your point, the simpler your HR system estate, the less paper-based systems that you've got, for example, the easier it's going to be to actually enforce and to be able to demonstrate that you've enforced.
And the last one is on the 7-year point. That is for all tax and salary related and financial information. Is that correct?
Yeah, so at that point in time, I mean, the 7 years was chosen because it's and it's a number of jurisdictions, but a number of jurisdictions have chosen 7 years to be the point at which taxation information expires. So that's usually the point at which an organisation is able to trim its its tax records and its employee details and reduce those down to the absolute minimum. So at that point, really, we're saying there should be very limited justification for keeping personal information. Beyond we employed this person between this date and this date. Beyond that kind of information, it's really going to be quite difficult to justify maintaining personal information.
Okay, so therefore, for any payroll system, you've got to retain data up to 7 years, but if your data doesn't hold payroll or expense data, then that could be significantly less than 7 years based on that model. Absolutely,
yeah, and again, every organisation is going to have to make their own judgment as to which duration is appropriate for their own organisation. The purpose of putting these together was to provide some thought, structure to the thought patterns that I, as someone who's been involved with data protection for some time, far longer than I like to think about, to put some thought and some structure to that, so people could understand that and make it applicable to their own environment.
Yeah, and thank you, Darren. And then organisations just need to have their own data retention policy, which specifies how long they retain data for what purposes, and how they're going to manage the deletion restriction.
Absolutely.
That would be sufficient for them.
Yes, absolutely right, Chris. You're 100% right there. They need to have that policy. If they're large enough that they have an internal audit team, then their internal audit team will obviously be measuring and auditing them against that criteria. If they, if your organisation is not large enough to have its own internal audit, then it may be that if you do have a breach and you should be investigated by the Data Protection Authority, if it be that serious a breach, then obviously you'll need to be demonstrating that you do have a data destruction and lifecycle process, and that you do have data retention policies, and that you can clearly state as to when data will be destroyed, how it will be destroyed, and that it will be securely destroyed, particularly in the case of both digital data and physical physical documents. You need to be able to destroy those securely, not just put them in the dumpster behind the building.
Great, thank you, Darren.
These are so this title of this slide is your HR system helping you achieve compliance. There are a number of factors that will help your organisation demonstrate compliance with the GDPR and achieve compliance with the GDPR. I've put these ones together as some high-level pieces that I definitely think are important, and they're important not only for the GDPR, but they are increasingly important and considered to be best practice and standard aspects for systems around the world. And increasingly, regulators are getting together at regulator parties. Some kind of strange events those would be, but getting together at regulator parties and discussing the things that they're implementing in their regions and applying them across regions. So you see many of these kinds of things will be represented in regulation for financial services companies, but they'll also be mentioned in standard best practices for other industry sectors as well. And not just, again, in Europe, for example, for financial services companies, there's a nattily named NYCRR 500 regulation in New York, which requires organizations to do many of these things, not specifically for HR systems, but to implement many of these aspects and to limit the number of interfaces and things like that, all the things that we've been describing during this webinar. So let's run through some of these and the importance of some of them. Multi-factor authentication. It's a bit of a technical term, so for those of you who don't understand what it is, multi-factor authentication is when you have one of those little RSA tokens that comes up with the 6 numbers that change once a minute, or you get a text message from your bank that says, type in this 6-digit code to validate you are who you say you are when you log in, those kind of things. That's multi-factor authentication. So the ability for your system, your HR system, to ensure that that you are who you say you are through more than one factor. So not just using a user ID and password, for example. That's the whole key aspect of that. Integrating the payroll system, that's really a simplification of the, limit the number of interfaces and exports you have to do of this personal data. Break it down to an absolute minimum, and integrating your payroll system is very much part and parcel of that. That's where many HR departments have some of their greatest exposures, is exporting that data into a CSV file or an Excel spreadsheet, and then sending it over to their payroll partner. Data encrypted in transit. So in transit means as it travels across the network within your organisation, but also as it travels across the internet to your organisation, or to and from your organisation, particularly if you're using a cloud-based system, as indeed XCD HR do. Having session timeouts. So once you've actually logged into the system, does it actually log you out after 5 or 10, 15 minutes, whatever period of time is reasonable? And ideally that's configurable as well. I don't know about you, but it's really frustrating sometimes if you just take a phone call and all of your systems have actually logged you out. So making that configurable is a nice aspect there. Ideally, your HR system should ensure good password policy. This should again be configurable to meet your organization's password policy. Should it have one? But making sure that passwords are appropriately complex would be.
Darren, I know we've got a number of people on the call today, the webinar today, who use the XCD HR system. And they will know that everything you've covered so far is part of our solution, and all of these settings are fully configurable to align with your policies, your processes, and your practices to make sure you're controlling and managing your data.
Yep, that's excellent stuff, Chris. Okay, data encrypted at rest. So once it actually reaches the HR system, it's actually encrypted on the database. The importance of the ability for staff to be able to maintain their own data. Talked about that a number of times during this webinar. People have to be able to update their data, or you have to provide the ability for that data to be updated. Part of the GDPR. It becomes your responsibility as the data controller to maintain the quality of that data and make sure that it's up to date. So if you're not providing the ability for people to maintain their own data, you're going to be probably having to employ additional staff to maintain that data on their behalf. So just have a think about that from that perspective. The ability to I always say this word incorrectly, so I'm going to give it my best stab. Compartmentalize. There we go. It's not so bad. Compartmentalize data. So that means breaking personal data and personal sensitive data out into different areas, and to be able to control who sees that data. So a person's manager shouldn't be able to see all of their personal information or personal sensitive information where that's not where that's inappropriate. So being able to split that information out and not just have you can either log in and you can either have access to the HR system and see everything, or you don't have an access. That's these days it's not appropriate for HR systems to do that, if it ever was, but certainly not these days.
And some of the more sophisticated systems, Darren, enable you to configure that data down into quite a lot of granular detail. So, for example, you may have an HR business partner who can only see specific data for a specific part of the organization, whether it's a department globally or whether it's a team locally in a specific country. So if you're able to segregate that level down to that level of granular detail, that's what to consider when you're looking at systems that can manage your data to that level of detail.
Yeah, absolutely. Good point there, Chris. GDPR reporting, you're going to increasingly see organisations talking about how appropriate it is to monitor and help you understand where you are, where you're exceeding your retention, for example, of certain information and things like that. So expect to see that kind of thing coming online.
Yeah. And within XCD, we're working with Fifth Step and Darren's team on a series of GDPR compliance reports, and those are going to be made available, to all of our existing clients before GDPR actually goes live next year.
Great stuff. Okay, we're just about reaching the end, towards the end of our presentation. So we're going to move into Q&A in just a moment. So if anyone has got any questions that they want to ask, we'll certainly do our best to answer as many of those as possible. But what we will do is on the podcast version of this webinar, we'll actually answer all of the questions, or any of the questions that we don't get to answer on this live session today. So So anyone who wants to ask any questions, do please start asking those now. You should be able to see a way, a means of asking those questions within your GoToWebinar client there. So what should you do next as an HR department? First step, you should look at appointing, potentially hiring, but appointing an HR data controller. This is probably going to be your head of HR. It might be someone else senior within HR. But the ideal is they have a good understanding of HR data, how the data is used, and the HR processes. So how the data is processed and how it moves through the organisation. And that needs to be for all systems, not just the digital systems or not just the paper-based systems. They need to have a good understanding of all of those ideally. Data categorization and mapping, so understanding what data you're collecting, how it's categorized in terms of the GDPR. So whether it's personal data, whether it's personal sensitive data, or whether it doesn't fall into either of those categories under the GDPR, and it's it's not GDPR applicable data. Understanding the data purpose or purposes. So while you're collecting the data, I would imagine that most HR departments are going to have at least two. If you have a pension scheme that's managed by the organisation, you may have a third one for that. But you're going to have at least two. One for hiring, so for the processing of candidates' data, and one for the processing of employee data. You're going to need to look at your HR systems and their ability to comply with the GDPR and how they're helping you. Use some of the criteria on the previous slide to help you with that. Obviously, if you're lucky enough to already be working with Chris and the XC team, then obviously you're going to be well on your path, well on the way with that. In fact, already there for the majority of those things. Working with the data protection officer, you're going to need to create a data incident response plan. What do you do if you have a data breach? Who do you communicate with? What actions are you going to take? How are you going to mitigate the problem? Now, under the GDPR, the organisation has to have one of these. Okay, and that goes for whether it's personal data belonging to customers, clients, or whether it be personal data belonging to your staff. The GDPR doesn't differentiate between those two; it's all the same. But you must have a plan, okay, and that plan must be able to demonstrate the ability to report to the Data Protection Authority, so that would be the Information Commissioner's Office here in the UK. There are many others across Europe, but you must be able to demonstrate your ability to report any data breach within 72 hours of it being discovered. Now, that's not just to say, oh, we've had a million records go missing. Don't really know how, but we thought we'd let you know. Actually, within that 72-hour period, you have to understand the nature of the records you've lost. Are they just HR records? Are they customer records as well? The type of data that's been lost, the likely impact to the data subject. So is this going to be, if you lost financial data, are they going to be getting spurious charges to their credit card or, to their bank? Is it loss of identity? Have you lost biometric information, for example? Have you lost details of their passport? Other information that might be used to clone their identity. And you also have to say how you've mitigated that and how you intend to mitigate the issue. It's not uncommon these days, if there is a data breach, for organisations to buy identity protection coverage for the staff or the data subjects who have been at the heart of the breach. So consider those kind of things. And all of those things have to be answered within 72 hours. Now, if it's an exceptionally large breach, you can go to the Data Protection Authority and say, we've done this, we're investigating this is where we are right now. That's okay. But you have to be able to demonstrate that you've got a plan and that you're working to it, and that actually it's the size and the nature of the breach that is delaying you, not that you weren't prepared for the breach. And the final point there, the yellow chevron there, is to be able to demonstrate compliance. This isn't about just ticking boxes and hoping that everything goes okay. It's actually being able to demonstrate the compliance on an ongoing basis. Because if a data subject were to make a data subject request, a personal information request, if they should do that, then you have to be able to present the information back to them if they ask for their data to be deleted, and then subsequently ask for a personal information request, and the data is still there that they've asked to be deleted. Then obviously you won't be demonstrating compliance, and they would be perfectly within their rights, and you probably would find they would be making a complaint to the Data Protection Authority. Now, such a complaint is unlikely, except in a very extreme case, but it's unlikely to attract a full 20 million euro fine, but you could find yourself being fined or note being taken by that Data Protection Authority to indicate that you've perhaps not been following the process. You're certainly going to get a warning even if you don't get a fine. Great. Okay. Well,
so Darren, there are really sort of three key parts to this. One is that you've got to have a set of GDPR processes and procedures that enable you to be compliant. Secondly, you've got to have a plan which you then put in place. And thirdly, you've got to have a way to be able to audit that piece on a regular basis. Is that a sort of high-level summary?
Yes, I think that's a fair summary, Chris. Yeah.
And it's potentially it is in order to have a fully documented set of processes and procedures that are enable you to be GDPR compliant. How far would it be reasonable to take it, to be ready by May? And do you see this as an ongoing piece of work, or is there a finite piece that has to be ready by May of next year?
Okay, so the GDPR is enforceable from May 25th next year. The Information Commissioner's Office and other data protection authorities around Europe have indicated that there will be a soft landing. They've used various different phrases, but have indicated there'll be a soft landing. Now, where they will be more harsh, let's say, or more likely to fine people, is where they can see absolutely no evidence of them taking any notice of GDPR. They're completely uncompliant, haven't been bothered, haven't attended webinars like this and taken action. They will be more likely to fine more heavily. Now, if you can demonstrate to a data protection authority that you have processes and procedures in place. They may not be fully there, but you have processes and procedures in place. My belief is that they'll be more lenient. Now, it will depend on the cases and the nature of the breach, but your aim should be to be compliant by 25th of May next year. But you certainly need to be able to demonstrate that you've got a project or program of work that's underway, and that you are working with your HR system provider in this particular case to ensure the data that your personal data and personal sensitive data is protected.
Okay, that's great. That's really useful, Darren. So really, it's an ongoing process of continuous improvement. Get to a reasonable and appropriate level by May of next year, and then have an ongoing program to improve that, enhance that over time.
Yeah, and I mean, one of the things I didn't include it as a chevron on here, but one of the things that Fifth Step certainly believes in is a process of continual improvement. And we believe that in many different ways. But in terms of GDPR, GDPR is most definitely a journey and not a destination. It's going to evolve. There are going to be new scenarios that are going to be faced by departments, and HR departments are going to be quite near the forefront of some of that because of the level and type of data that they hold. So making sure that, from an HR department, if nothing else, that your organisation is in good shape, really is a good starting point. There's going to be lots of other touch points within the organisation where personal data is likely to be captured, but making sure you're in a good shape from an HR perspective is something you really should be doing, and being able to demonstrate that process of improvement and the steps you've taken so far.
Okay, thank you. I'm conscious about time, Darren. I'm going to ask, make one more statement, and I'll let you answer a few questions. I'm conscious that people want to drop off. For those of our clients that are on today's call, thank you very much for joining the call today. As a next step for this, we will be doing another webinar, which will talk specifically to our own existing clients about how our system enables you to be GDPR compliant, the steps we're putting in place, and we're also going to run a number of workshops as well for those who are interested. So we want to work with you to help you put your process and policy and procedures in place. To that effect, if also you want to use an external consultant such as Fifth Step, then we would recommend to support that piece. We're not going to do consultancy ourselves. What we're going to do is to provide you with a system to enable you to be compliant. And we are going to put in place a GDPR audit service to our clients if they want that for the future. So, Darren, are there any questions that you've had that have come in that you want to respond to, or
absolutely,
are we going to follow up those later?
Well, there's a couple of questions here, so I'm going to cover those off right now. And please, if there are other questions, you all should have received an email today with my email address do please, if you think of these afterwards, do please mail them over. We'll be putting together the podcast and any additional answers over the next probably over the next 3 or 4 days or so. So if you do think of something, then do feel free to drop those by email. So let's get to the first question. Amy, your question was, what are your recommendations for global organisations where data needs to be shared outside the EU? Okay, so the data that's being shared outside the EU is going to be your personal data. I'm making that assumption on your behalf, Amy. There are a number of ways that you can do this. You can have an organisation sign a contract which essentially ties them into treating the data in a GDPR compliant manner. Okay, so you can do that if you're working with a third party, for example. If you're sending the data to another part of your organisation, then it's pretty much a similar process, making sure that the other parts of the organisation understand the nature of the data and the constraints on the use of the data, and that it's not going to be put into a system that then just does mail shots. Okay, so it's a twofold process. Okay, making sure that that you've got a contract in place that stipulates the way the data can be used. Okay, and there are many examples of those. Some organisations call them third country contracts. Okay, because it's the third type of country. Those countries being those within the EU, they're first countries. Second countries are those who have got equivalents, GDPR equivalents, and third countries are those who do not have GDPR equivalents. Okay. I hope that answers.
Darren, on that, can I just add one piece on that? Because I've seen this before, and I've been asked this a number of times by some of our clients, and certainly in some of the presentations I've given on this, is that the personal data held on employees, such as their home address details, such as their bank details, passport details, that information is primarily used for payroll processing, for benefits, for pensions, for contracts. All of that information should only really be used for the specific country that they're in. You don't need to move that information or make that information accessible outside of that country. So if you have a global solution and you have an HR team who needs to be able to see data globally, what you may want to consider is actually hiding all that personal information to that group of people, and only allowing them to see, for example, role data, salary data, performance data. So that will reduce the sensitivity of data that you're moving cross-country and cross-border.
Yeah, that's an excellent mitigation there, Chris. Good. Okay. Amy, the last piece I will add to that, to answering your question. So, if you should be sending the data outside of Europe, it still remains your responsibility or your organisation's responsibility to ensure ongoing compliance with the GDPR. Just because you've sent the data elsewhere doesn't mean it's out of sight, out of mind. Your organisation is still liable should that data be lost or breached, from a third party that you provided it to, or to an internal, different part of the organisation in a different jurisdiction. Okay, I'm going to run through these next ones. Nick, privacy notice or privacy notice given to candidates on new hires. Do you have to decide lawful reason for collecting data, e.g. consent to fulfil a contract or to comply with the law? Yes, Nick, you do. However, the purpose has to be in plain English, so it can be very much you're providing this information to facilitate the employment process. You can certainly go into details of why do we need to see your passport, for example. You can certainly go into the details of it's the employment process and to comply with local regulation. I hope that answers your question, but yes, it needs to be clear and plain English as well, though. Paul, okay, you have asked, I'm thinking of issuing a range of privacy notices over the life cycle, one pre-hiring, two offer and application process once hired, one pre-induction, induction, new employees, etc. Does this seem like a reasonable approach? You've listed out a few there, Paul. I've just summarised them back. That could be a reasonable approach if the way that you're going to use the data or the type of data you're collecting is going to change dramatically. It's probably not, so you might want to think about how you could simplify that. If you could just put one purpose, and actually the data collected is going to be, for the purpose of employment, meeting regulatory requirements and legal requirements, processing payments, those kind of things. You're unlikely, or perhaps post probation, if you're including them in other benefits such as medical cover or life cover or something like that, you may be adding those kind of things either at that point or as part of, you may say to provide other benefits. Okay.
One of the ways you may want to cover that is within a contract of employment or within a policy, one of your policies. So rather than giving, cover it through to the policies and contracts, for example.
Yeah, that's true. As long as it's nice and clear, as long as it's drawn out, you can certainly repeat it in your contract of employment. You can also repeat it within the employee handbook and those kind of things. Just make sure it's drawn out and clear to to the data subject, to the employee in this case. At the point or before they've actually provided their personal information, ideally. Okay, and Amy, back to you again. One more. I think this is the last one. Should we ask staff for consent if our head office, which is outside of the EU, wants to review our data? I would suggest, particularly for HR, that you would want to be saying that your data may be processed outside of the EU. To facilitate, to get consent from the in the first instance. Okay, so right from the outset, you're saying that your data may be processed in other countries in accordance with the purpose and to the same standards as as the GDPR, as the same standards as within Europe. That's permissible. You may, in some extreme cases, for some people, get an objection to their data being sent to the United States, for example. I've certainly heard of that in some instances before, where they don't want their information being going to the US. but in most cases that will actually cover you off. So certainly you will need to ask for consent if the data is going to be processed. And remember, process means collected, stored, changed, updated in any way, or viewed, okay, in a country outside of the EU.
Darren, thank you very much for that. I think now is the time where we will follow up any other questions to all of you via email. We'll also send out the slide deck as well. I'd like to thank you all for joining today's presentation, specifically thanking Darren for today's webinar and for enlightening us about how simple and easy GDPR is going forward and how we're all going to be compliant in May of next year. It's an exciting challenge, and we look forward to working with our clients and prospects around meeting that challenge going forward. So Darren, thank you very much, and thank you everyone else, and wish you all a very good day.
Yep, thanks Chris, thanks everyone for attending.